State of Ohio versus Marlon Johnson. That's case 18CA011329. Each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. When you begin your argument, just let me know if you wish to reserve time, and if so, how much. Don't use the names of any victims or children throughout the argument. We have read your briefs. We are ready to begin when you are, Ms. Bremke.
Thank you, Your Honors. I would reserve 5 minutes of my time if I could. Again, thank you for the accommodations today. I know you're rescheduled from last week. This case presents 5 assignments of error. It's a lengthy indictment in which there are multiple convictions. The most serious is 13-count indictment, the most serious being the aggravated murder. The 5 assignments of error, the first one is the defense counsel requested the transcripts of the grand jury and was denied those transcripts. And the standard we know is that the defendant must show that there's a particularized need. He did, and again, this is transcript page 29 and 30, is when the defense counsel raises this issue. And part of what he presents is that there was switching stories, recounting is what he calls it. The main witness, I'm going to refer to her as MD. Everyone says this is a drug house, that there's drugs being involved. Every single witness, I believe except for the minor, had admitted to drug use or alcohol use that night. And even the officer had said, yes, this is a drug house. All of the witnesses, there was a lot of switching stories even throughout the trial. And again, the defense counsel brings this up as a particularized need, given the fact that these stories are constantly changing, that nobody had a consistent story, and that was obvious even before the trial had begun. The second assignment of error is ineffective assistance of counsel. So,
excuse me, counsel.
Sure.
Did defense counsel raise an objection after testimony, or was this a pretrial motion? I'm trying to draw a distinction between a speculative pretrial allegation of potentially inconsistent statements versus the issue being raised after the inconsistency appeared through testimony at trial, if that makes sense.
So the transcript pages that I pointed out to you are definitely before there was testimony. That was at before the trial, I think the morning of the trial. I don't believe it was brought up again. I could be wrong. There could have been an ongoing objection. But I know definitely was brought up, before the trial.
And so the particularized need here would be the need to impeach witness testimony or to test the credibility of the witnesses. Is that particularized need here?
Right. It was the switching stories. And again, this was obvious to defense counsel even before the trial began. And the fact that these witnesses, again, there was obvious credibility issues with the fact that they were all using drugs and impaired on the night of this incident.
Remind me, did you cite case law that has found a particularized need in those scenarios to test the credibility or to impeach?
Specific to drug use?
No, not necessarily. Finding that types of issues are have been found to be particularized needs.
I believe so, yes.
Okay, thank you.
And second assignment of error, ineffective assistance of counsel. So it's a unique situation that only a few weeks before the trial began, the defense counsel admitted that he was unprepared. had said he was unprepared, to go forward with trial. As a result of that, the court actually appointed a second attorney, but it was only about 2 weeks before the trial began. So again, that attorney had very limited time to prepare for the trial.
Well, counsel, in that regard, when I'm going to say attorney number one brought to the court's attention that he was unprepared, as I recall, he asked for an investigator. Did he say why he was unprepared?
No, not necessarily, but he, not to my recollection, but he had been the attorney from the very beginning. So when the case started at the municipal level, at the preliminary hearing level, he was the attorney. So, I was prepared that you might say, well, it was a time issue that he ran out of time, but that's not necessarily the case because he had the case from almost day one, essentially.
Well, but almost day one wasn't all that long, was it? I mean, as you started out this argument, this case involved a lot of counts in the indictment. Now, certainly his client, now your client, did not have to waive time. But, what effect does not waiving time have on a general argument of unpreparedness? Or can you point to something specific in the trial itself that would show unpreparedness?
So this isn't the first time that I've come up with this issue. So I know you guys have seen it before too. It's a balancing act of, the defendant's right to not waive speedy trial versus the attorney's being prepared. And that's, again, why I point out that, this attorney was involved from day one, even if it was a somewhat short period of time. I mean, this incident happened on New Year's Eve, and the attorney was involved, within days of that. He says on March 29th that he's unprepared. So, and before the court. So that is, 90 days later, this is the first time he's asking for an investigator, which he asks for and he gets permission for, but never pursues. He could have located additional witnesses or tracked down. Like I said, these witnesses are very unreliable, very inconsistent, and that's an issue that could have been taken care of with that investigator. There's also, a coroner who testifies that there was clothing that wasn't tested, and again, he doesn't ask for an expert on that. He doesn't file not a single motion, and to be honest, most of the trial is actually done by attorney number two, who just gets involved, a week or two before, 2 weeks, I believe, before trial. So that, again, it deprives my client of effective assistance of counsel. And I understand the balancing act of the time, but, 90 days or so into the case, he's saying that he's unprepared, and there could have been an indication, from the very beginning, from my client that, I'm not going to waive speedy trial and this is going to be a fast process. And there could have been a way to handle that in other ways. So again, that doesn't, just because the client doesn't waive speedy trial doesn't forgive the attorney's obligation to be effective. The third assignment of error is that Mr. Johnson was deprived the right to a fair trial because there was erroneous jury instructions, and that revolves around the flight instruction. So a little bit about the facts as far as they go to the flight instruction. There was this incident in the house, and then everyone kind of dispersed, and Mr. Johnson was in the driveway. He was not he was in a vehicle but wasn't driving. There was another driver, and there was conflicting testimony. So some people, Mr. Johnson had said that nobody had told him to leave, and that I don't believe he even heard the police tell the driver not to leave, but the police had testified that they told the driver not to leave. Regardless, the argument was that he wasn't told not to leave. He was in the vehicle and the driver had left. And there, when he was found and arrested, only a day or two later, he was found locally in Lorain County. He hadn't left. There was no indication that he was fleeing that night, and so
was there any indication he was trying to evade the officers prior to his arrest?
No, I don't.
Found hiding in a house, that sort of thing.
No, I don't believe so. He was arrested. There's no charges to that effect.
So you're basically saying that he simply didn't remain at the scene, and
Right.
That's not okay.
Right. That was the argument, is he simply didn't remain at the scene, and there really was conflicting testimony on whether anyone told him to stay at the scene. There was, there was some testimony that they told the driver to stay, and told, she was parked in the driveway, and when the police first got there, they said, hey, just stick around. That was one of the testimony, was that they told her, stick around, and he was in the passenger seat, and she took off. And
what's your argument as to prejudice? Let's assume that there was error there. What's your argument as to prejudice?
Well, again, I think that it's, that kind of jury instruction taints the jury's view of Mr. Johnson, that he was trying to get away because he had done something wrong. The jury instruction itself, again, I think is a little bit harsh for somebody who was found locally, there was no real testimony that he had gone to a different state or anything along those lines. And the jury instruction basically says, hey, you can take that into consideration in his guilt. So I think that is a prejudice, that it appears as if he did something that was wrong right from the beginning, from the jury instruction.
Ms. Bremke, I'm sorry, I'm getting distracted by a constantly ringing doorbell. I hope if you hear it, I hope it's not bothering you. I suspect there is a 6-year-old behind it, and you are into your rebuttal time.
Okay, I'll make it quick.
But you can keep going.
Yeah, I'll make it quick. There's sufficiency argument and manifest weight. The sufficiency, so Mr. Johnson actually did take the stand. He testified, pages 628, 629. He testified that he did not go in there to rob anyone. He didn't go in there to kill anyone. That wasn't his intention. That, if you look at the facts, and again, they're lengthy, we don't have a lot of time to get into it, but essentially there was a scuffle earlier in the night with Mr. Johnson and his girlfriend. He came back later in the night with Mr. Perry, and who has a lengthy history and actually received some consideration for testifying. There really isn't sufficient as evidence that my client had caused the death. There's no real eyewitnesses. MD, again, as I'm going to call her, she was what you would call the closest thing to an eyewitness, and she said that that my client was always in the kitchen when it happened, and most of the shells were found actually in the basement, not in the kitchen. There's more evidence that Mr. Perry had killed, again, TD, I'm going to call him, and then my client. MD had also said that Mr. Perry had threatened to kill her. That's transcript page 284 when she testified. The manifest weight, again, goes to the credibility of the witnesses, which I've talked about repeatedly. MD she says that she was, the more sober she gets, the more she remembers, which we know just isn't, that's not how memory works. That doesn't just come back to you when you're sober. And she also at one point says, I don't remember, God, bring it back to me, something along those lines. Again, every single witness is saying that they were, WM says, transcript 364, 390, that he had shots of alcohol, that he was buzzed, that he was smoking marijuana that night. the minor witness, TM, he says that he doesn't see anything. He's playing Xbox in his aunt's room. So again, these witnesses that testify lack credibility is for manifest weight of the evidence. I'll reserve the rest of my time.
Well, you don't have anything left to reserve, but I will let you make a summary statement at rebuttal. All right, Ms. Paprocki.
Thank you, Your Honors. Lindsay Paprocki of the Lorain County Prosecutor's Office on behalf of the state of Ohio. In response to Johnson's first assignment of error, the state submits that because he failed to establish a particularized need for the release of the grand jury transcripts, the trial court properly exercised its discretion in denying his request. He did move for the release of the grand jury transcripts prior to trial and argued that he was entitled to the transcripts to determine whether certain witness testimony was inconsistent with their current version of events. In essence, he speculated that witnesses had recanted their testimony and would be shifting stories. And the release of grand jury testimony under such circumstances has been rejected under case law. We did cite case law in our brief where Ohio courts have consistently held that the release of grand jury testimony requires a showing of particularized need, which cannot be established based on speculative pretrial allegations of potentially inconsistent testimony. Ohio courts have specifically held that particularized need cannot be established for pretrial release of grand jury testimony based on anticipated inconsistency with true testimony which has not taken place yet. Here, Johnson's request for the grand jury testimony was based on no more than speculative belief that his testimony, that the witness's testimony might contain inconsistencies with trial testimony that had not even occurred.
Wouldn't that result in a huge delay in trial if the defendant has to wait for each witness to testify, make a motion after each witness that their testimony is inconsistent? And how would they know if it's inconsistent if they don't have the copy of the grand jury transcript? I guess what I'm saying is if there's an indication that there is going to be inconsistency, wouldn't that be a purpose that would outweigh the continued need for secrecy? You know, test credibility, to impeach. It seems like that. Go ahead, I'm sorry.
I see what you're saying. But I think it's that the fact that in this case the request was just simply premature, and all that the request indicated was that there was going to be shifting stories. There was no indication that these witnesses had testified before the grand jury. And it was just simply a premature, very light offering of evidence to show a particularized need. I'm going to shift around the assignments of error a little bit and move to the sufficiency argument that Johnson made, arguing that there was insufficient evidence of prior calculation and design to support his aggravated murder conviction. This aggravated murder conviction relates to the 2018 New Year's Day shooting death of a male who served as a doorman to a drug house, which Johnson frequented and often, and had been kicked out of just hours before he returned, unannounced, armed, and unwelcome. He pushed his way through the door, shooting and killing the victim who had slammed the door behind him previously. The circumstances leading up to the shooting reveal that he had sufficient time and opportunity to plan the murder and made a calculated decision to do so. Although the phrase prior calculation and design is not defined in the revised code, by its term it suggests an advanced reasoning to formulate a decision and purpose to kill. Here the victim of the murder, TD, as I said, served as the doorman to the house where Johnson was aware that if someone unwanted came to the door, he would not open it. While there was testimony that Johnson and the victim had no bad blood, there was also testimony that he had slammed the door behind Johnson and was kicked out of the house for physically assaulting his girlfriend. Johnson admitted telling law enforcement that he felt like he was not wanted at the house that night. And although Johnson and his girlfriend frequented the house and often got into arguments there, he had been put on the notice that the next time it happened, he would not be welcome back. There was evidence then that even that Johnson's relationship with the victim and others at the house had become strained, and that he specifically set out to return to the murder site where he was unwanted and he was aware the victim would be and stand as his impediment to returning and opening the door. In fact, eyewitness testimony established that Johnson returned unannounced and armed, forced entry into the back door while the victim was attempting to lock the door. That same eyewitness testified that Johnson almost immediately pulled out a gun and shot the victim while the victim was standing in the doorway to the kitchen. That altercation that led to Johnson's ejection from the house occurred hours before the ultimate shooting death of the victim, which gave Johnson sufficient time to reflect on the incident, deliberate, and plan the murder. In fact, Johnson went to 2 bars after being kicked out of the residence and stayed until 5:30 a.m.
I don't think anyone said anything, Lindsay.
Okay.
You're good.
Okay. Sorry.
That's okay.
Johnson met the other individual that went with him to the house at an after-hours bar, at which he learned that individual was armed with a gun, at which he put into his vehicle. He then directed that individual to drive him back to the residence where the shooting occurred. And this was and courts have held that the presence of sufficient time and opportunity for the planning of a murder between events such as an argument creates a reasonable inference of prior calculation and design. And the state would submit that this evidence taken together and viewed in a light most favorable to the state was sufficient evidence of prior calculation and design. Johnson also asserted in his brief that there was no evidence of causation to support his convictions for murder and aggravated murder because there was no evidence of an eyewitness of the shooting. And this argument is somewhat hard for the state to understand and actually quite bewildering, as the first witness that testified for the state, who has been referred to as MD, testified outright that she saw Johnson shoot TD. She testified that Johnson forced his way into the door when TD was attempting to lock it and shot him in the kitchen. She repeatedly testified that she witnessed Johnson pull out a gun, shoot TD after forcing his way into the door, and that he was standing in the doorway to the kitchen, which led to the basement, where they then ran after the shot was fired out of the kitchen. This testimony is consistent with Detective Kovach's testimony about where the location of the shell casings were found and the probable locations of the shooter. Johnson also ignores WM's testimony that Johnson confessed to him, "I shot TD and I think I killed him." The state would submit that in construing this evidence in the light most favorable to the prosecution, there was sufficient evidence on the element of causation to sustain his convictions. After TD was shot and killed, there was also evidence presented by the state that Johnson fled the scene, sufficient to support the flight instructions. Following a shots fired call, 2 officers immediately arrived at the residence. A vehicle was observed running in a vacant lot next to the murder scene. Because the vehicle was backing out of the driveway, one of the officers immediately made contact with both the driver and the passenger, and this was evident from a dash cam video of the first officer's vehicle, and that dash cam video depicted the officer speaking to the female driver and the male passenger, who was later identified as Johnson. That officer testified that the vehicle's occupants advised him that a shooting had just occurred in the residence, and as a result, the officer advised both parties to stop and wait. That was specific testimony from the officer. Despite the officer's commands, the vehicle pulled away and left the scene with Johnson in it. Johnson was arrested a day later. Now, despite that testimony, Johnson maintains that the flight instruction given by the trial court was an error. Now, a flight instruction is within the sound discretion of the trial court whether to give that. And flight means some escape or affirmative attempt to avoid apprehension. And it's been held that it is not an error to give this instruction when there is sufficient evidence in the record to support the charge. The state would submit that based on that testimony of the officer and the dash cam video, there was sufficient evidence in the record to support the conclusion that Johnson did flee after being told by law enforcement officers to stay at the scene, and he did that to avoid apprehension.
So he was not driving. He's a passenger in a car that leaves.
Mm-hmm.
What is the behavior of Mr. Johnson? I mean, it seems like the state is relying on the behavior of the woman passenger.
The woman driver?
The woman driver, I mean, merely being a passenger in a car that departs from the scene is now flight? Aren't we looking at the defendant's behavior, not the female driver's behavior?
We are looking at to establish the flight instruction, we would have to be looking at the defendant's behavior, correct?
So what did he do other than sit in a car that was driven by somebody and left the scene? Mere departure from the scene is not a deliberate flight by this individual, is it?
I think if you look at the second part of the definition, avoiding apprehension, and he was not located, he was located and arrested a day later. And
well, tell me what additional evidence there was that he took some affirmative steps to avoid detection or to avoid apprehension. Is there anything in the record to support that? Other than simply not remaining at the scene as a passenger in a car?
I don't recall any additional evidence, what he did after he fled the scene, after he left the scene after being advised to stay.
No evidence of concealment, he used a false name, he resisted arrest, none of that sort of thing?
I can't recall, honestly.
I have a question in that regard. Did the female driver testify during the trial?
Giovanna's shaking her head no, so.
I will take that as a no. Thank you. Fine.
I'm going to turn to the manifest weight argument now. And as we know, manifest weight goes to the credibility of the witnesses. And here we again go to the fact that Johnson claims that no one testified that they witnessed him shoot TD, and instead relies on his own testimony that another individual was the shooter as being more credible. He also attacks the credibility of the state's witnesses by claiming that those who were in the house on the night of the shooting were all high and drunk. Johnson yet again fails to acknowledge that the state had eyewitness testimony that he in fact shot TD. Johnson also again fails to acknowledge the impact of his confession to WM that I shot TD and I think I killed him. Although Johnson testified in his own defense and continues to maintain that TP shot and killed TD, the jury had an opportunity to view the witnesses and was in the best position to assess the credibility of the evidence presented by the parties at trial. This court has said it will not overturn the trial court's verdict on a manifest weight of the evidence argument simply because the trier of fact chose to believe certain witnesses' testimony over the others.
And with that, you are out of time. Thank you.
Okay, thank you.
Ms. Brumke, a very, very brief summary sentence or two.
Yes, I'll make it brief. So again, we ran out of time. We have 5 assignments of error. We just ask that you review the assignments of error, find in Mr. Johnson's favor, and reverse and remand for further proceedings. Thank you, Your Honors.
All right, thank you very much. We will take the matter under advisement, issue our decision in due course. It'll be mailed to both sides, as well as posted on our website and that of the Supreme Court. Everybody have a good rest of your day.